My name is Scott DeVito. I am an associate professor at Florida Coastal School of Law. This PowerPoint presentation is a part of a series that I will be building starting summer 2013 to provide students with a resource for understanding the law of contracts. The sole purpose of these presentations is to provide legal education. They do not give any legal advice. If you need legal advice on contracts law, please contact an attorney in your geographic location. This PowerPoint presentation is designed to give a basic overview of the law of contracts from a litigation perspective. I will post a presentation later to give a basic overview of contract drafting. Contracts law is fairly complex, but the good news is that it has a very natural progression, and as you learn contracts law, you should be able to see how each part of contracts law flows into the next. As a beginning law student, or one reviewing contracts law, you will want to organize the rules that make up contracts law into a structure that makes it easier to recall and to see the connections between the various rules. Law professors usually call this process the outlining process. Let's begin our outline by identifying the 6 big topics into which you can put everything you will learn in contracts class. For now, I will just click through each topic and give a basic overview. A little later in the presentation, I will give more detail on each topic. Choice of law. The law governing a contract changes depending on a few basic factors. For example, whether the contract concerns sales of goods or services, and whether the contract concerns activities occurring between parties that are both located in the United States versus activities occurring between parties where one party is in the United States and the other is in another country. Binding obligations. You will learn that there are a few ways where people can interact, and as a result, one person creates an obligation to another that is enforceable under contracts law. Defenses. Sometimes people engage in conduct that looks just like they formed a contract, but because of social policy or pragmatic reasons, those contracts are not going to be enforced by the court, or the court will conclude that no contract was actually formed. Interpretation. When people have a disagreement about the meaning of an agreement, then the court will have to figure out what the contract says. In essence, it will have to interpret the contract. There are a range of rules that tell the court how to do this. Breach tells us how to decide whether a party has failed to perform an obligation that is due, whether that failure is a breach, what kind of breach it is, and what the non-breaching party can or should do as a result. Damages are what the party suing wants from the court. Sometimes it is the court ordering the breaching party to do what is promised. Sometimes it is the court ordering the breaching party to pay money. So damages rules tell us what the court can order the breaching party to do. Let's get a bit more detail about choice of law. In a year-long contracts class, you generally cover 3 areas of law: CISG, UCC, and common law. The CISG is the United Nations Convention on Contracts for the International Sale of Goods. When we have an international sale of goods, then the contract is governed by the CISG. We have to be careful at this point because the words international, sale, and goods are each defined by the CISG. As a result, you could have what in common sense looks like an international sale of goods, but the CISG does not apply. Or you might think that something wasn't a good, but the CISG applies anyway. So to know if the CISG really applies, we would need to work through these terms. For our purposes today, we won't. Our goal is to be very simple and just give the broad strokes of contract law. We will return to choice of law in a later posting, but for now, we won't go into detail. Article 2 of the Uniform Commercial Code applies to the sale of goods. As with the CISG, the UCC has very special definitions of the terms sale and goods. A quick point. Sometimes students get the UCC rule confused because they think of it as the domestic version of the CISG. So they say the UCC applies to the domestic sale of goods. This is incorrect. Because the CISG has special definitions for international, sale, and goods, there may be an international sale of a good that doesn't fall under the CISG. In that case, the UCC might apply. Once again, because I am just giving a broad overview, I won't define these terms today, nor will I explain what the UCC is. When we discuss choice of law, I will. Finally, we turn to the common law. I haven't put up a specific rule for common law, but instead have listed it as the default rule. In essence, if neither the CISG nor Article 2 of the UCC apply, then the common law does. Because we have a little bit of material under our belt at this point, I want to pause and talk for a second about outlining. What you see on the screen is the traditional way you would outline the material we have discussed so far. You will notice that the outline gives a structure to the material and compartmentalizes everything. The point I want to make here is that you don't have to use this method of organizing to organize your material. For example, you can organize your material in the way I have been doing up to this point, using flowcharts. You can also organize the material spatially, using something called the route method. In the route method, you visualize some space you know very well. You then attach concepts or ideas to different parts of the space. To remember, you visualize yourself walking through the space and seeing things to which you have mentally attached a concept. I have created a little house floor plan here as an example. You could easily put different things in different rooms. For example, you could put Article 2 of the UCC in the kitchen, the CISG in the living room, and the common law in the dining room. You would then attach different concepts to the objects in these rooms. When you see the microwave in your kitchen, which is where Article 2 of the UCC is, you might remember the definition of sale. Another approach would be to associate concepts with images. Take a look at the images I have listed. What type of law does each one stand for? The Eiffel Tower stands for the CISG because it's international. Hardware store stands for Article 2 of the UCC because you buy goods there. A mowing service stands for the common law because here we have the provision of a service, not a good. The key point to keep in mind is that different people learn and remember differently. As a law student, your job is to figure out how you learn and remember most efficiently. If you keep your mind open to ways of representing the material, you will figure that out more quickly, and your life will be a lot better as a result. Let's move on to the next big subject area. From this point on, I will keep things very high level and avoid a lot of detail. If you don't already know contracts law, too much detail at this point would be overwhelming. There are three core ways in which one party can become obligated under contract law to another. Contract formation is the way we all think contracts happen. You go to the car dealer shows you a car. You offer to buy at a price. There is a back and forth. The dealer makes a final offer. You accept. You get the car and pay the car dealer. This is a big part of contract obligations, but not the full story. Promissory estoppel can arise when a person makes a promise to another and the other person relies on that promise. In certain circumstances, that promise plus that reliance means the person making the promise is going to have to do what was promised or pay the person promised some money to compensate the promised. Restitution usually arises when there isn't any kind of contractual or promissory relationship between the parties. In certain circumstances, even though you don't have a contract and didn't make a promise, you have an obligation to another party to pay them some amount of money. An easy example is if you were in a car accident and unconscious on the side of the highway. The ambulance comes up, picks you up and loads you into the ambulance. They drive you to the hospital, where the hospital provides care to you. During this entire time, you are unconscious, and there's no way you could agree to that deal. First, the deal of, hey, I'll drive you to the hospital in our ambulance and keep you safe for X dollars. And then the second deal of, hey, we'll treat you and make sure that you get better for Y dollars at the hospital. You certainly didn't agree to any of those because you're unconscious. Nonetheless, under the theory of restitution, you're going to owe the hospital and the ambulance company money. One more point about restitution. I'm using the word restitution fairly broadly here to encompass a few concepts: restitution, quasi-contract, and unjust enrichment. I do so because those concepts are all related and because the details of the differences between them are outside of the scope of this podcast. Just keep in mind that if you hear those other terms, they fall under what I have labeled restitution. Gifts are one more big subtopic that tends to fall under binding obligations. In gifts, pay attention to the difference between completed gifts, where you've already given the gift, and promises to give gifts. So you gave a promise to give a gift at a later point. Once you give a person the gift, it's pretty hard to get it back. When you make a promise of a gift, sometimes that creates an obligation to give the gift, sometimes it doesn't. If you have figured out what kind of law applies and then have established that you meet the basic requirements to form a binding obligation, say you seem to have formed a contract, it still doesn't mean that the contract will have any effect, because contract law allows parties to raise two types of defenses to contract obligations. Formation defenses literally say that even though you seem to have met the elements to form a contract, the court is going to act as if you didn't form a contract at all. Take the old Western example of an unscrupulous rancher trying to make the widow sell her land so that the rancher can have her water rights. He comes to her house and threatens her. Perhaps he points a gun at her. As a result, she signs the deed over. This is physical duress, and if you can prove the elements, the court will allow the widow to act as if she never signed that deed. The contract was never formed. When there is an enforcement defense to a contract, the court says, even if a contract was formed, we refuse to enforce it. In essence, the court tells you it does not matter whether there is a contract. You can't use the courts to enforce your bargain. One of the most important enforcement defenses is the statute of frauds. The statute of frauds says that if certain types of contracts are not in the right kind of writing, then the court will not enforce the contract. Contracts relating to land are one of the kinds of contracts that have to be in the right kind of writing. Imagine that I orally offer to sell you my house for $200,000 and you orally agree to buy it. At that point, we have formed a contract. Let's say that later on I want to back out of the deal. We have a contract, so you sue me to enforce it. When we get to the court, I will argue that even if there was a contract forced, the court shouldn't enforce it because it wasn't in writing. If successful in arguing the statute of fraud defense, even if the court believes that a contract was formed, it will refuse to enforce it because of the statute of frauds. Let's assume you have a contract formed and there are no defenses to its enforcement. At that point, we might disagree about what the contract says. In essence, no one disputes there is a deal, but we honestly disagree about what the deal means. To interpret the contract, the court will use rules of interpretation. For example, when a contract is a general term, say you are buying a red Honda Accord in one place, but a more specific term later, say the color is identified as Basque Red Pearl 2, the court will interpret the earlier use of red as Basque Red Pearl 2. Sometimes the parties have formed a contract but did not specify the meaning of certain terms or said they would agree to agree later on. This is a kind of indefiniteness, and there are special rules to deal with it. The wrong kind of indefiniteness can mean that no contract was formed at all. Finally, there is the parole evidence rule. This rule tells us what kinds of evidence we can introduce to figure out what the contract said when at least part of the final contract is in writing. When you enter into an agreement, you will have obligations to the other party. When you don't perform those obligations, you will be considered in breach. There are different kinds of breach, so one thing contracts law does is define the kinds. For example, in the common law, we have minor or partial breach, material breach, and total breach. Depending on the kind of breach, there will be different effects on the various parties. In some kinds of breach, the non-breaching party still has to perform his or her duties. If they don't, then they will be in breach. Other kinds of breach suspend the non-breaching party's obligations, and yet others discharge them. I have added a subcategory called anticipatory repudiation. This covers situations where you learn that the other party isn't going to perform its obligations before that party's obligation is due. Assume on May 1st, you and I enter into an agreement where I agree to paint your house on June 1st for $3,000. Then I call you on May 15th and tell you I won't pay your house. Notice, my duty has not yet arisen. I am to paint on June 1st. This is May 15th. So technically, I haven't actually breached the contract. I could still show up on the 1st and paint the house. If there was no chance that I would show up on the 1st, it would be problematic to make you wait until then to find a breach. So in certain circumstances, you'll be able to say there is a breach before the obligation is due. So in this case, before June 1st. That will enable you to find a suitable substitute for my performance and get the performance you want in a timely manner. Damages come in two basic types, monetary and non-monetary. When someone has breached a contract and caused you harm, monetary damages is the money the court orders the breaching party to pay you to compensate for the harm caused by the breach. When the court orders non-monetary damages, they are ordering the other party to do something. This is often called specific performance. So if we have a contract for me to buy some land from you and you breach, the court can order you to sell me the land for the price. One final set of points. First, analysis of a contract's problem will usually proceed from left to right on this flowchart. For example, when a client comes to you with a contract problem, you will first identify the choice of law. That determines what rules of law you use for the rest of your analysis. Then, using the rules for that type of law, you identify what binding obligations were made. Is there a contract? Was there detrimental reliance on a promise? And so on. This gives you your basic causes of action, what basis you can sue for damages on, or what basis you can be sued for damages on. Next, you look to see if there is any defense to the contract, a way you could argue that a contract should be considered either never to have been formed or that the court shouldn't enforce even if it was formed. With these issues down, you want to know if there was a breach. But before doing that, you have to make sure you know what the contract said. So you have to analyze the agreement in light of the rules of interpretation. At that point, you should know what the court will think the agreement said. This is vital because the view of the parties may not line up with what the court will think. Now that you know what the contract says, you can figure out if there was a breach and what type it would be. Finally, if there was a breach, you can decide what potential damages would be. One more point. Sometimes you need to interpret before you check for defenses. So interpretation can precede the analysis of defenses. For example, if there is ambiguity as to the term of the contract, meaning how long the contract will cover. So let us say it's not clear whether it would be for a period of less than or more than 1 year. You would need to figure that out through the rules of interpretation before doing the defense analysis, because there is a statute of frauds defense that makes contracts that cannot be performed within a year of their making unenforceable unless it is in a writing. That ends this presentation. The goal of the presentation was to give you a very general and broad introduction to the kind of topics that arise in contracts law in a way that gives you a broad schema for organizing them as you learn them. I hope this has been helpful. Thank you.